Hello everyone, and welcome to our session. Thank you for joining. My name is Simon Gleeson. I'm a partner at Rothenberg, and we're really pleased to be joining Taylor Wessing here today for the webinar, where we'll be focusing on the tax and legal considerations when engaging a workforce in the UK. I'm going to introduce the team shortly. However, I just need to address some housekeeping items first. The audio is muted just to preserve the quality, as the session will be recorded and available afterwards. You do have the opportunity to ask questions, so please do via the question panel on 24. Please make the most use of that. So, why are we covering this topic? The UK continues to be a leading destination for companies seeking to accelerate growth. And just as an example of that, in 2017 there were over 1,205 FDI projects, with many investors citing talent, the ease of setting up, as well as some of the lucrative incentives out there to come to the UK. In terms of the World Bank ranking, the UK is about 7th out of 120 countries, the ease of doing business, and really also seen as a proven platform for future expansion. So, in our roles, we're regularly asked what are the best ways to engage workers that are cost-effective, tax compliant, and legal. So today we're going to provide guidance and insights on the options which are available to you from a tax and legal perspective. So just to briefly introduce the team, here at Rothenberg we're a market-leading accounting, tax and advisory practice. We provide support and advice to global organisations, and that really varies from startups right through to larger multinational clients with subsidiaries across the world. I'm joined by Lee Hamilton. He's a partner in our global mobility team who helps organisations around employment and expat-related matters from corporates to non-profit. So he'll be sharing his thoughts from a tax perspective. And then covering the legal side is Paul Callahan and Rachel Farr from Taylor Wessing. So Paul's both a partner and heads up the Employment, Pensions and Mobilities Group and advises corporate clients headquartered in the US, in Canada, around all their UK legal needs. And Rachel is a senior employment lawyer in Paul's team who really specialises in all types of employment work. So, just going into the agenda. To keep it really simple, we're going to look at the different stages of employment, walk you through some of the considerations that you should be aware of, and take questions throughout as well as the end. If we don't cover all the questions, then we'll certainly find a way to reach out to you afterwards. So, without further ado, into the first topic, Paul, I'm going to ask you to take it from here.
Sure. Thanks, Simon. So, getting down to basics, most people who are outside of the UK will be used to a two-tier employment status situation of having to determine whether someone is an employee or self-employed. And we do have those two different statuses in the UK, but we also have a third status, an intermediate status called worker. Now, an employee is easily recognisable, somebody who usually turns up to work every day, although increasingly these days we're seeing people working at least part of the time from home. They essentially work in the way that they're told to work, so they're supervised. They have to turn up, so they're told what their hours are. And essentially all of their work equipment is provided for by the company that they're providing services to. Often they have to provide exclusive service, and they certainly almost won't be allowed to work for competitors. And employees in the UK have a full range of rights. So unlike in the US and to some degree in Canada, there's no at-will employment in the UK. So if an employee has been employed for at least 2 years, they have the right not to be unfairly dismissed. And there are certain minimum notice of termination requirements in the UK for employees. They're also entitled to certain benefits. Most obvious one that's certainly different from what you might be used to if you're based in North America is the vacation entitlement. And under UK law, all full-time employees are entitled to an equivalent of 28 days paid vacation, and that includes the 8 public holidays we have in the UK. And there are certain obligations as well to auto-enroll employees onto a pension. The UK is generally considered to have the most flexible employment laws across Europe. So, for example, in Ireland, unfair dismissal rights kick in after just 1 year's service, and employees can get injunctions to insist that they remain employed during the period when you have to follow Irish law processes, and compensation for failing to follow Irish law is a lot more expensive than in the UK. In the Netherlands, once somebody is not just a temporary employee, you have to go to court to be allowed to terminate their employment. And in Germany and France, works councils are particularly common. So, although the UK is a little bit more regulated in terms of employees than North America, it's very much seen as a bridge between North America and Europe in terms of regulation and ease of doing business. Now, workers are people who are not employees, but are also not working on their own account. And what that essentially means is that anybody where there's no obligation to do work, to offer work or to accept work, but they're not actually self-employed business people. So, for example, there might be casual workers. Quite typically in this day and age, people working in the gig economy, where there's no obligation on the company to provide them with work, and they can choose which work they take and which work they don't take. They will typically be found to be workers under UK law. And what that means is that they don't have unfair dismissal rights or rights to notice of termination because there's no obligation to give them any work. But they do have those vacation rights, and they do have the right to the national minimum wage, and they also potentially have pension rights if they earn enough to hit the auto-enrollment threshold. So that's the second intermediate category, where you have a certain amount of flexibility, but you still have some obligations. And self-employed / independent contractors, those are people who are genuinely working on their own account. Typically your plumber or a consultant who comes in for a while to carry out a project. They work the way they want to work because they are the experts. They don't get told how to carry out their work, and if they need any equipment, they'll generally have their own equipment with which to do the work. Agency workers are another category that we'll go into a bit more detail later, but essentially when someone's supplied by an agency under EU rules, there are certain rights that they have to the extent that they need to be treated to some degree in the same way as your regular employees. So that gives you a basic summary of the situation from an employment law perspective for the different types of people. And Lee's going to talk you through what that means in terms of tax.
Hello, Lee Hamilton here. Thank you, Paul. So looking at an employment tax from an employment tax point of view, it's slightly easier and more straightforward than the employment law position, in so much as there is no worker status, i.e. you're either employed or self-employed for tax purposes. However, it still causes a lot of confusion and there are grey areas, and the reason for that is because, much like employment law, the tests around whether somebody's employed or self-employed for tax purposes is not defined in statute, but it's based on case law, which then drives a number of different tests which the Inland Revenue use to determine whether somebody's employed or self-employed in the UK. And of course, if you're a business outside of the UK, thinking about how you engage people for the very first time, that's kind of a key decision. And one thing that I come across quite a lot is people saying, well, can we just get around any of our obligations by self-employing somebody? And of course, actually, you can't. It's not that straightforward, because actually we've got to look at first whether that person is genuinely self-employed, not only for employment law, of course, but for employment tax purposes. And the reason that's important from an employment tax point of view is because, quite simply, if you're self-employed, then it's the individual's responsibility to satisfy their compliance obligations with regards to paying tax, essentially, on any income that you pay them. And we do have scenarios, for example, where US companies have individuals, UK individuals who work in the UK on a self-employed basis, and essentially they just pay them gross, and the rest of it really is down to the self-employed individuals. Now, on the flip side, if somebody's actually an employee, then it becomes the responsibility of any employer in the UK to operate pay-as-you-earn. Now, one of the sort of tests in that regard as to whether, especially if you're an overseas company, is really around whether you have a permanent establishment in the UK or branch which is able to operate pay-as-you-earn, or which the revenue can seek pay-as-you-earn from. And I'll be talking a little bit more about that in the coming slides.
Okay, so it's Rachel here, and I'm just going to talk about what in a way is probably one of the simplest options, which is to directly employ your employees, either via a UK or a non-UK company, because from an employment law perspective, whether or not the employer is incorporated in the UK or in another country makes no difference to UK employment law, because these will apply as long as the employee is working in the UK. Direct employment gives you the greatest level of control over what the employee is required to do and how precisely you want them to do it. UK law already vests some intellectual property rights directly with the employer in any case, and it's a relatively simple matter to make sure that you've got all the protections that you want in the employment contract. Because the employees are working directly for you, it's very clear that you have a business interest to protect, which will justify you putting, for example, post-termination restrictions and non-competes in the contract if that's what you decide you want to do, and those are more likely to be enforceable. And similarly with confidentiality obligations, it's very clear that the information they have is because they're working for you as their employer, and it's relatively straightforward to get those protections in place. As Paul mentioned, in the UK, employees you have to have a fair reason and follow a fair procedure before you dismiss employees with more than 2 years' service in order to avoid a claim for unfair dismissal. Employees are also entitled to notice of termination and, depending on the circumstances, to severance payments if you lay them off, make them redundant. Employees, like other types of workers as well, are also protected from discrimination claims. Sorry,
so I can just say there's one question that's just come in. It's from a US tech company, and they're just pointing out that we're looking at potentially hiring in the UK and exploring PEO. I've been advised that it can take nearly 4 months to set up an entity and register as an employer. Is that correct?
We're certainly seeing a shorter period of time than that. Where the timing becomes more crucial perhaps is around immigration issues. I mean, if all of these options, if you're trying to bring people in who aren't UK or EEA nationals, there will be timing issues for all the options. But we're seeing maybe 6 to 8 weeks to set up an entity and get a bank account.
Okay, good, thank you.
And in fact, we can set up an entity in 24 hours. That's really easy. It can take a bit longer to get a bank account in the UK because of the anti-money laundering rules, but getting the entity itself is really straightforward.
Okay. This is also probably a good moment to mention auto-enrolment into a pension scheme, which I know has just been touched on. It applies to all what they call job holders in this legislation, not just employees, so it would include workers as well. And it needs to be factored into the cost of all workers, along with tax and national insurance contributions, whether you choose to employ them directly or whether you hire them through another structure. Really only the truly self-employed, and as we talked about, there are issues around who's truly self-employed, escape auto-enrolment obligations. But broadly, if a worker is earning over the qualifying threshold of £10,000 a year, the employer at the moment has to put in at least a 2% minimum contribution into a pension scheme, and the worker must put in 3%. This is up to a certain level, it's not necessarily on the entire salary. And as you can see on the slide, those amounts are going to be rising in April next year. But to stress, this is something that you'll have to consider as a cost, whichever option you choose, as agencies and PEOs and so on would normally bundle these contributions up in their rates. The good news, I know it sounds horrible to say you have to have a pension scheme, is that actually it can be very straightforward. There are a lot of advisors out there who would help you to choose an appropriate scheme. And there's also the government, when this legislation came in, set up something called Nest, which is designed to be simple and easy to use for employers to set up. So there's a lot of advice available on how to set it up, how to do the enrolment, and any payroll agency, if you chose to use a payroll agency, would be able to handle all of this in a very straightforward way. As I said just now in answer to Simon, if you're planning on a local workforce, then immigration isn't an issue. But if you want to bring over any of your existing personnel, you need to consider how. I mean, we find it's very common that people do want to bring at least one person over to manage on the spot. And typically your employer, your company, will need to have a sponsor license from the Home Office in order to start bringing people in on visas. And then you can either, if they're new hires, you can do that, or you can bring people in on an intra-company transfer.
Great, thank you, Rachel. So from an employment tax perspective then, if you're doing business in the UK for the first time potentially, then a straightforward option, especially if you plan to be here longer term, is to set up a UK subsidiary, which in essence becomes the employer then for any new UK employees that you bring on board. In that case, then it's straightforward from a tax point of view. Employees go on the payroll and pay as you earn, which is UK tax withholding for our overseas friends, and NIC, which is UK Social Security, is operated then by that UK employer. That said, it may be early days for you, and I know many businesses especially who are just thinking about the UK market want to dip their toes in the water, as it were. So you may decide actually simply to employ, at least for the early stage, your individual based in the UK via your overseas entity. Now from a tax point of view, that's perfectly fine. The key thing, however, is to make sure that a review is undertaken to make sure that that individual isn't creating unwittingly a corporate presence for you in the UK. And just to explain that point, even where you don't register an entity, the activities of an individual who are operating on behalf of a non-UK employer can create a corporate presence for you in the UK. Essentially, that's where the UK authorities would say, actually, you're operating now here as a corporate, and therefore we're going to require registration, set you to corporate tax, etc. So that's one thing to get reviewed, I would say, up front, because that will then drive whether you need to operate pay-as-you-earn and NIC where you've got no subsidiary here. So we do have clients, for example, where they've established there's no permanent establishment in the UK, so the UK-based employees simply self-assess. They satisfy and submit and report to the Inland Revenue themselves as individuals and pay tax in that way.
So one question that's just come in, and maybe this is something that you want to comment on, Lee, is in terms of the 3% minimum individual contribution under auto-enrollment in the pension scheme, is that something that's based on just a base salary, or is that applicable to all earnings, or do people have the choice?
It's based on relevant earnings for auto-enrollment, so that would just be their gross earnings. Okay, so if you were like a salesperson who had a base salary and then commissions based on OTE, then I guess that's probably where that question is coming from.
Yes, it would be, well, there's a minimum threshold, which is about £10,000 a year, and then there's a maximum of up to about 41,000, and it's on that chunk in the middle, so it's not the whole salary. It's just, I mean, if they were earning commissions and so on, it would be rolled into that 41,000, but once they get over that, it's not going to be any higher.
Thank you.
Okay, thank you. And then, I suppose one point just to finish off that section I wanted to mention, especially with regards to any employers based within the EU. Currently, this is, of course, pre-Brexit. But even if, as an employee, you don't have a corporate presence here in the UK, if you have employees who are based here, then you're still required to register to operate employer and employee UK national insurance. It's something that I've seen a few people get caught out by. In one case, a German employer was employing an individual here over a 10-year period and hadn't actually realised that they were obligated to operate national insurance. Of course, there was inquiry, and the UK government are within their rights under the current EU framework to then demand that social security from the German company. So any EU companies, that's just something to be wary of. You can't pass on that responsibility to the individual.
Okay, we're now just going to take a look at secondments, because it's pretty common that a company, especially when it's just getting going in the UK, although it may well actually be quite mature in the UK, will want to second people over from another office, most often where they're headquartered, and we see this a lot, particularly with North American companies. And obviously there are many advantages of that. It's somebody you know, you trust, somebody who can help the new office in particular integrate into the whole corporate structure, because they can spread the ethos and the spirit of the parent company overseas. So it is a very popular thing. And generally, it's short term. Often we see them for 1 year, 2 years, sometimes up to 4 years before the individual is sent back to their home country. And during that period, it's most common that they would receive enhanced benefits to cover any additional costs, because if it's a temporary assignment, then it's very likely that they won't want to sell their home. They may well have additional school fees. You may have to think about costs to the family to come over. It may well be agreed that you will pay the individual and their families to return to their home country once or twice a year. All of those sorts of things are typically up for negotiation. But on the employment law side, well, firstly, there are some immigration things to be aware of, which Rachel is going to cover, because it is really important, if you are thinking about sending executives to the UK, that you set up a proper entity in the UK rather than go a different route like the PEO model. But the other thing to bear in mind is that anybody working in the UK on secondment, certainly after the first few weeks, is very likely to have UK employment rights. And what that means is that if they have an employment contract at the moment in their home country, or if they're in North America, then more typically they might just have an offer letter. They will need to have a secondment or an assignment agreement to cover their period in the UK, which has to tick those mandatory legal boxes that everybody who is an employee working in the UK has to have. And for example, another thing to bear in mind in relation to secondees is if the employment is terminated whilst the person's in the UK, it may well be that there are post-termination restrictions like non-compete provisions and non-solicitation provisions that you would want to apply to that person, because you may have them under local law, wherever they're from. But if that person was due to stay in the UK, you'd need to ensure that they signed up to something that would work in the UK. So you need to have alternative non-compete and non-solicitation provisions, because generally the provisions that you have in the UK in a US or a Canadian agreement would not be enforced in the UK. So essentially you need to have two different types of terms running concurrently for somebody who's likely to go back to their home country but is in the UK for more than a few weeks. And I'll just let Rachel explain some of the immigration issues to be aware of when you are sending secondees over.
Okay, well typically the normal structure we see is that employee one will come across on a sole representative visa with the intention of setting up the entity, getting the bank account, and then once that's in place, everybody else can be brought across in an intragroup transfer, on an intragroup transfer visa once there's a sponsor license for the new entity. The visa process means that however you decide to structure your operations, you do need to allow time to get the visas you want if you want to bring in non-UK, or as I say at the moment, non-EEA nationals. And pensions-wise, just to note, though this gets quite complicated, that if someone's been seconded to the UK, pensions auto-enrolment may still apply because, again, they are working in the UK, as Paul mentioned.
So we had a question actually from the same company from before, who was looking at actually hiring in the UK and potentially sending somebody over now. We've spoken about different models and PEO. I think we probably just need to clarify what PEO is, because there's some confusion about how PEO would fit in, say, could that be a model that would work for hiring and sending people over, or would you have to have two different approaches? It's a bit confusing.
Okay, well, a professional employer organisation, it is very difficult, to be absolutely honest with you, to get non-UK people in, because the act of using a PEO and that kind of structure where your employees are being employed by the company that isn't actually running your business, means that you close off some really valuable visa options. They're not part of your group structure, for example, so you can't use an intra-company visa to get them in, and it can be difficult because the Home Office doesn't necessarily understand some of these models terribly well. It doesn't fit very well with the process we have. To get people in on a Tier 2 general visa isn't easy either.
And also you're potentially taking an employee out of their own employment rights and contractual obligations in the US and pushing that to a third party where that would become null and void unless they rewrote their contracts, right?
Exactly, yeah. They'd be moving to a completely different entity which didn't actually have any legal connection to the home country. So a PO is an increasingly popular model, and occasionally it can be a good idea if you're putting, say, one person in about 5 or 6 different countries at the same time, because a PEO will basically be the employer of those people, and that means you don't have to worry about being registered and all of the bureaucratic hassle there. But as Rachel said, it does mean you could never send anybody over from your home country, and it's a very short-term option at best, really, because there is a lack of control, a lack of contractual nexus between you and the actual individual if they're actually employed by a PEO.
Great. So from a tax point of view then, one of the points I want to start with around tax is that tax is driven by two things. One, where you're resident, and secondly, where you're performing duties as an employee. And I wanted to mention that point because I do come across a few cases where actually people are seconded from an overseas company and simply they remain on the overseas payroll. Tax remains being held from the overseas payroll. Nothing is kind of sorted from a UK point of view. So actually, if you're going to go down the secondment route, one of the important things to review early on is will that individual continue to be liable to tax in their home country when they come to work in the UK? And secondly, then what are your obligations from a UK perspective from a tax point of view? Now, in almost all cases where somebody's contractually seconded to the UK, then they're going to be liable to UK tax from day one in respect of their work in the UK. Now, there are some cases where people aren't formally seconded, but for example, they come to the UK to undertake business visits, and that can happen, in the early days of when you're just deciding whether or not the UK market is for you and having exploratory meetings, for example. Then the UK double tax treaty network, which is with most major tax levying countries, enables those days to be exempt from UK tax where certain conditions are met, primarily that salary continues to be paid from outside the UK, cost of employment continues to be borne outside the UK, and that individual spends less than 183 days, normally in a tax year or in a 12-month period, depending on the treaty. So if it's not a business visit in those early days and it's actually a formal secondment, then you need to be looking at tax from a UK point of view, and then actually affecting, withholding, and putting those people on the payroll. Now, an important point to mention is that actually Social Security is dealt with entirely separate from tax, separate set of rules. And it can be a little more complex simply because actually Social Security can, whether you're required to operate in UK national insurance, is dependent upon a number of factors, including the country from which you are seconded. So broadly, we see the world divided into three when it comes to Social Security: secondments from the EU, which are governed by their own set of rules; secondments from countries which the UK has a reciprocal agreement with; and then what we call rest of world countries. So to give you an example, if somebody was seconded into the UK from Germany for 18 months and they remain contractually employed by their German employer, then they would stay in the German social security system and no UK national insurance would be required. They would be required to obtain a form called Formula 1 from their home country in order to prove that no NIC is required, but essentially you get out having to operate that from a UK point of view. So to summarise that bit, important to look at the tax piece, where it's not a business visit, but actually a formal secondment. Then tax will be due on UK work duties, and then looking at the social security position, secondly, to work out whether that's due in the UK or overseas or not. And finally, one thing with secondments that can be beneficial is that the UK has quite a generous tax relief with regards to assignments to the UK which are deemed to be temporary. That's anything which is 2 years or less. And what that enables is employers to provide tax-free accommodation, provide reimbursed utility bills tax-free, cover home to work travel tax-free, and for subsistence costs to be provided tax-free as well. And that can really help employer costs, especially in the early days. And also, actually, it's quite rarely these days in the UK legislation, it's an actual deduction. So if the employee pays for those things themselves, then they can actually deduct that from their tax bill. So a little bit of planning up front, and also you can manage costs with regards to secondments too.
Okay, so just to look at the third stage of self-employment. Now, if a company is thinking of dipping its toe into the market in the UK, doesn't want to set up an entity, doesn't really want to have any employees and the worries that go with that, then hiring a self-employed consultant or taking someone on that way is really attractive, because they're responsible for their own tax, for example. They don't get any employment rights. You don't have to worry about any of the things that we've spoken about. The important thing with somebody who you're looking to treat as a self-employed contractor is that they genuinely are. And the debates over whether someone's genuinely self-employed are similar in most countries, certainly in the US and Canada. So really, for them to be self-employed, we need to see that they're in control of the way they work. They can turn down work. They provide their own equipment. They don't have to wear a uniform if in the business your employees would wear a uniform, and they're generally free to do the job the way they want at the time they want, just like a plumber coming into your house or anybody else who you would see as an independent contractor. So, for example, for a tech company that was thinking of setting up over here, it would be someone given a specific project just to get on with it. In an ideal world, they'd have other clients too and wouldn't be working for you full time. And then it's always possible to see how it goes with that consultant and then change the way they operate and make them an employee later on if you feel that you do want to actually set up properly over here in the UK. The really important thing is that you can say in all honesty that the way they work is different when they're an employee to when they're self-employed. Because UK law will look at the reality of the situation irrespective of what any agreement says with them.
And just picking up a quick question here, is there like a defined period by which someone can act as a contractor before really they should be treated as an employee?
Not really. And if they're genuinely a contractor, then they can be a contractor forever. But if in truth they're working full time for you, then anything more than a few months starts to look like employee status, unless you can really distinguish from the way that they're working that they are genuinely self-employed, no one's giving them daily instructions, and that they're a business person who ideally will be looking to get new clients in the future.
I don't know if it's like a legal or from a tax perspective, but we have a case at the moment where companies looking to convert someone from a contractor to an employee, and they're getting a little bit of resistance from the employee. I wonder whether it's for tax reasons and financial reasons rather than legal reasons. Perhaps something that you want to comment on, Lee.
Yeah, I mean, we see that, especially I think in the current climate where the government is actually consulting on employment status and is looking at, giving extra scrutiny to the area. Actually, employers are looking at it as well more closely. But you're right, in many industries, actually, self-employment has been the norm for a long time, and changing that culture can be difficult. I did come across a company recently who had a self-employed individual working for them, and they'd been there for 15 years within that business, and it had just not been looked at. And part of the rationale and reason they'd given was that it was very difficult to get resource in their sector by direct employment. So from a tax point of view, then it's a lot of the similar sort of considerations really from a tax perspective in terms of whether somebody's an employee or should be self-employed. I think the thing I want to say is just again, as I said earlier, to caution against just assuming the self-employed route for tax purposes. Of course, the attractive point, the attractive point from an employer perspective is that where somebody's self-employed, then you don't have to worry about pay-as-you-earn, having them on payroll. There's less cost in terms of secondary national insurance costs, etc. But if you get that assessment wrong, then as an employer, it's deemed to be your responsibility, and the UK Inland Revenue would hold you liable to the UK underpaid withholding and social security. And it's something that we regularly deal with, where actually the Inland Revenue have undertaken a pay-as-you-earn audit here with the UK company, have identified individuals who in reality should be employees for tax purposes, and have then actually imposed a tax levy on the organisation itself in respect of historic taxes, and also assessed penalties and interest thereon. From a UK point of view, the Inland Revenue can look back in the first instance 4 years for pay-as-you-earn when assessing whether any historic liabilities should be due, and 6 years for national insurance contributions. They can go back further where they deem there to have been deliberate evasion, I guess, in that regard.
Okay, just to very briefly move on to something called personal service companies. Now that's the type of self-employment that you see quite commonly from people who do consider themselves to be business people. So they will have set up their own company, they'll be the only employee of that company, but it'll be that company they want to contract with you through rather than as an individual. And from an employment law perspective, that can be attractive because that person is going to be an employee of their service company, less likely to be an employee of of you as the company that's contracting with them. The disadvantages really are in relation to control, because the truth is, if that person is creating intellectual property, if they're dealing with your clients, if they get to know your business plan, you don't really just want to contract with that one-man band company or one-woman company, because it will be the individual themselves who's actually potentially going off and taking your confidential information or whatever it is. So in that sort of situation, we'd always recommend a tripartite agreement, so that it includes the service company, but also the individual. And we want the individual to be there, particularly in relation to the intellectual property and the confidential information provisions. And if you wanted non-compete, non-solicitation provisions too, then those really would need to be in relation to the individual, because they're not going to be of much value if it's just their company that you can go after. But I'll let Lee tell you about some of the tax implications of that risk.
Sure. Yeah, I mean, having your own personal service company and engaging the worker via a personal service company has historically been seen as quite an attractive option for employers or engagers from a tax point of view. And the reason for that is if an individual is deemed to be an employee from a tax point of view, actually the responsibility to operate UK tax withholding, pay-as-you-earn, and national insurance, that falls currently to the personal service company, provided that personal service company is based in the UK. So currently, if you're an employer and actually you don't ask the right questions and misassess somebody's employment status, then actually you've got an argument to say you're not really too concerned, because really, if you get it wrong, it's not your responsibility. The reason, I caution and mention historically is because actually a lot of employers are now reviewing the position in that regard, and the reason for that is the government has a consultation out which is recently closed and is actually looking at essentially removing that kind of default position where the compliance defaults to the personal service company. What does that mean? Well, it means that if, as an engager, the employer, you get that status wrong from a tax point of view, then it will become your responsibility to operate pay-as-you-earn and national insurance from an employment tax perspective. Now, one thing we've been asked is it likely that this will be enacted and come into law? And I think the answer to that has to be that it is highly likely in some shape or form to be changed and to come in. And the reason I say that is because the government have already changed this in the public sector from 6th of April of last year. The press that they're putting out, at least from their point of view, is that it was a successful endeavour. So I think it will be really difficult to see a position whereby they wouldn't change that for the rest of the economy going forward. So I think personal service companies are an attractive option, but I would just caution, and also I think the best thing to do as an engager is really to satisfy yourself that that individual is self-employed, even where they've got their own personal service company.
And now turning to agency workers. Traditionally, agency workers would be used for temporary work, either for a specific project or for a fixed term period. However, we do see arrangements where they're used for a much longer period or on an open-ended basis. Typically, an agency arrangement traditionally would involve a worker, the employment business, the agency, and then the end user. However, we do sometimes see it structured so that perhaps the employment business actually employs the worker, or that the agency worker has an intermediary such as a personal service company like we've just been talking about, or an umbrella company which enters into a contract with the employment business. Depending on those arrangements, the agency worker may actually be an employee or a worker of either the agency or, in fact, the end user itself, or of neither. So you really need to look very carefully at the contractual arrangements to see what the risks and benefits of those arrangements might be. There are certain things you can put into the contract, and I'll come on to those later, which can reduce the possible risk that an agency worker be held to have a claim against the end user. Agency workers generally have the right not to be discriminated against. They have a right to the national minimum wage. They have the right to be auto-enrolled in a pension scheme if they qualify for it by whoever pays them, even if they're not an employee in that case. The agency worker regulations, which I know Paul mentioned as well, give agency workers the right to the same pay and other basic working conditions as equivalent permanent staff after they've worked for you for 12 weeks. So at that point, any perhaps cost savings by having agency workers will start to be reduced because they're entitled to that same pay. I mean, from day one, they do also have access to collective facilities like canteens and anything else you offer to your permanent employees, and to information about employment vacancies. Agency workers generally can't get visas in a typical arrangement because you have to work for the company that's sponsoring you. There are certain circumstances, perhaps maybe where it's an agency which has a business around outsourcing, providing an outsourcing service to other businesses. They might be able to get a visa, but even then those are going to usually be time limited.
Thank you. So from a tax point of view, of course, agencies are another option in terms of securing labour in the UK and workers. And again, from a commercial point of view, it might be an attractive option from the point of view that the agency would actually pay the individual and also operate payroll and so on. Now, under the UK legislation, essentially, if you contract via a UK agency, the UK agency supplies labour on your behalf, then it will be that UK agency which is responsible for operating any payroll, tax, pay-as-you-earn, national insurance. Following changes a few years ago in 2014, one thing to watch out for is, if you're using an offshore agency, i.e. an agency not based in the UK, then the liability to operate pay-as-you-earn or national insurance can fall to your end client. So obviously that was something that you wouldn't want to put upon anybody who you're trying to engage with in the UK from a client point of view. So using a UK agency, it will default to them as agency to operate pay-as-you-earn. So I guess we've, just to sort of take stock where we're at, we looked at some of the options thus far in terms of employing somebody directly via a UK company, possibly a subsidiary that you've set up. We've looked at just employing individuals directly by your overseas company. in the UK, also seconding individuals from the overseas country into the UK. As part of that, you can decide, if you're engaging people directly, whether you do that via a personal service company, which offers some protection now from a tax point of view. And then finally, using agencies there, potentially to secure labour, which might be useful, especially in the early days. I think the final section we've got is on professional employers organisations.
Great. So we've already alluded to PEOs earlier on, and they can be a really attractive option, certainly initially when you're thinking about doing business in Europe, but don't necessarily want to set up any sort of entity at all. I see them most commonly where there are a number of different countries where a company might want one or two workers, and they feel like that it might be too bureaucratic to set up companies in a whole range of European countries. Although, in actual fact, there's a bit of a misnomer there, because usually just about every European country will allow you, if you set up a UK subsidiary, to employ through that UK subsidiary. But the advantage of the PEO is that they essentially handle everything. They are the employer, they deal with payroll, they deal with all of the administrative costs and hassles in relation to the people that you have on the ground. Inevitably, that means you pay for it, so there is a big extra chunk on top of your what would have been your payroll costs if you work through a PEO, which I guess is fair enough because they're providing you with that service, so you'd expect it to come with a fairly significant chunky price. From an employment law perspective, it is difficult, and some European countries really don't like them. The UK, it's possible, but bear in mind that means you will have people who are not really your employees. You'll be thinking they're your employees, but there will be no contractual relationship between you and the individuals. What that means is that, strictly speaking, you can't control them, you can't discipline them, you can't actually fire them if you need to fire them. All of that would need to be done by the PEO. Potentially even more importantly, any intellectual property that's created won't be owned by you, but will be owned by the PEO, and you won't have any chance at all of enforcing any non-compete or other post-termination restrictions, because you didn't have any contractual connection with these individuals themselves. You will need to indemnify the PEO in relation to anything that happens, because the PEO will essentially say, although you don't have those rights in relation to the people, you are going to have to indemnify them if any of the individuals ends up bringing a claim and suing in the UK or anywhere else in Europe. So, to be honest, from an employment law perspective, it can be really useful at first, but they're pricey and not very, and certainly not very legally helpful route to use, certainly in the medium to long term. And Rachel's already mentioned about the visa restrictions. You might want to just say a little bit more about that.
Yeah, I mean, it's very difficult to get visas for non-UK nationals because the PEO is outside your business's group. So you can't use the sole rep option to get the first person over. You can't use the intra-company transfer route. Occasionally we have seen PEOs work with clients to try to get a visa, but even if they do manage that, the next step you have is the problem when you're trying to perhaps bring the employees who have been employed by the PEO into your own organisation, because aside from all the cheapy problems you may have when you try to transfer them from the PEO, it may not even be possible. As a general rule, you may have to terminate their employment and then rehire them. But if you do manage to do all of that, the sponsor licence will be tied to the PEO, so you'll have to go through a lot more admin costs, time taken to get those employees where you really want them to be.
Great. And I think from a tax point of view, ultimately if the PEO in the UK is employing the individuals, then it will be their responsibility to operate pay-as-you-earn and national insurance in respect of those individuals. However, I think a huge sort of flag at the start of any engagement, I would recommend it's reviewed from a tax perspective. And the reason for that is because engaging people in this way to, fulfil contracts with UK clients or do business in the UK in some shape or form does not, allow you to circumvent the rules with regards to, for example, whether you, as an overseas business, create a permanent establishment for tax purposes in the UK. And you can see the logic in that. If you're an overseas company and you decide actually we've got a load of UK contracts, but we don't want to set up UK subsidiaries, so we'll use a PEO company to outsource our employment. Actually, there's a huge tax loss there, potentially, to the exchequer from a corporate tax point of view, because nobody's paying corporate tax in respect to those profits being generated from a UK point of view. So that will always be the case, and I think what I would say is, at the start, much like if you are setting up yourselves a subsidiary, setting up yourselves with an employee in the UK and employing them directly, is to review that from a tax point of view and satisfy yourselves that there are no permanent establishment, there's no permanent establishment being created from a corporate tax perspective, and you've no obligations from that point of view. I think then you'll have at least some assurance that the PEO model is going to work for a time.
So just one question here. Says, I work in HR and we are in the process of buying a company. I know this because one area I've been asked to look at is moving people over. I'm not clear if we're using an agency or PEO, but we have employees in some countries and other employees who will be or who are with third-party agents at the moment. So what will be the process to wind that down or bring them all under one roof if we would be directly employing them?
Well, because the business, you've always been operating the business, it's going to be quite difficult to transfer them under the operation of the law with the duty transfer regulations that we have in this country. So what we have seen in the past is it becoming necessary to terminate those arrangements, terminate the agreement you have with whether it's an agency or a PEO, and then take on board those employees directly. As I say, it's something it's possible to do, but there's an awful lot of hoops to go through depending on exactly what your arrangements are. It sounds as though maybe that's something that we can help you with, and then to make sure you've got everything in place.
Definitely do your due diligence to make sure any IP, etc., is owned by the company that you're buying, for example. Sorting out the legals when you've got that complex situation is particularly important.
I know they say number of countries as well. So are there fairly similar approaches in each country, or is it quite disparate?
It's quite disparate. A lot of continental Europe is more heavily regulated, and they don't like it when a company that is the beneficiary of work is claiming not to be the employer. So depending on the country, you may risk various issues with the local inland revenues, and that's something definitely to take local advice on depending on the country.
Okay. So I think in looking at the various different topics that we've covered today, it's been quite a lot, and certainly we'll be distributing a copy of the recording afterwards. There was just one final slide, which is around the top areas to look at. So from a legal and tax perspective, if I can try and keep you to 3 or 4 suggested areas to look at each from a legal and tax perspective, what would those be? I think I'll start with you, Lee.
Yeah, I think from a tax perspective, it's getting the plan together, quite frankly, before you actually set up into the UK. It's working out who is it you need in terms of resources in the UK. Will that be UK national, or do you want to second somebody in from your parent company? And that's often the case, for example, where there's particular skills or knowledge of the company and what you want to achieve, etc. So working out how you want to engage, I think, from the outset is important. And then going through the steps around, okay, so if you've decided you want to engage with, by sending a couple of secondees over and perhaps a couple of UK local hires, then understanding what does that mean from an employment tax perspective, and then implementing thereafter. And I do think that should be done at a high level at the very start. Where I see issues being created, I think there are two avenues really. One is where people simply dive into a particular solution because it's something that they've been told, or somebody else has done it who they know, without really thinking through whether that's right for them. I think that's number one. And then I think number two is really having chosen whether you're going to self-employ somebody, use an agency, use a PE and so on, it is really just to do your due diligence and understand what your obligations are.
Okay, from my side, I'd say the first important thing is, do you know that you definitely want to come to the UK now, or is it just that there is a particular person whose skills you want? If there is, then it may well be that they can be a genuine contractor, but if you're looking to properly enter the UK market, then you probably need to think about setting up an entity and having a direct employee. And that's so much simpler than people realise. Rachel, what do you think? Because it's particularly from the immigration perspective, I guess.
Yes, I mean, you're right. It's definitely, I think, direct employment is the most straightforward way to go, or secondments, of course.
Yeah.
That's the way to go. But the other option, self-employment, assuming that these people don't have any personal link with the UK, that they can get a personal visa. If we're just talking about business visas, self-employment is out, PEOs are really out, agency workers are out. So employment is probably the way ahead.
Great.
Good. Well, I'm going to take this opportunity to thank our panel. Thank you, Rachel, Paul, and Lee. We hope you found it very useful, and if we can be of any further assistance, then please don't hesitate to contact us. So thank you. That now concludes today's session.